There's a legal shift happening right now in AI voice protection, and almost nobody is connecting it properly. In December 2025, the US Patent and Trademark Office did something rare. It granted soundmark trademarks for a celebrity's actual voice. Then in April 2026, Taylor Swift filed for the same kind of voice trademark protection. Together, these two examples are testing whether trademark law can do what no federal law currently can: protect your voice from AI deepfakes. So here's what you're going to take away from this video. There are 4 legal tools that currently exist to protect your voice from AI. By the end of the next 8 minutes, you will know exactly what each one does, exactly what each one fails to do, and which one is being tested in real time right now to fill the gaps between the others. If you're an artist, a content creator, or an athlete, this is the legal landscape you are currently operating in, and most of you have never had it laid out clearly. Let's fix that. Quick disclaimer, I'm sharing legal information to help you understand your options and the landscape. Every situation is different. If you need legal guidance, please consult an attorney in your jurisdiction. With that being said, I'm Stevie. This is Girl Code of Law. Let's get into it. Tool number 1 is the one most people assume covers everything: copyright. Here is what copyright actually does. It protects fixed creative works. But here is what copyright does not do, and this is the gap that defines the entire AI voice problem. Copyright protects the singular recording of the audio. It does not protect the voice itself. Your pitch, the timbre, your cadence, your breathiness, the way you pronounce certain words, the rhythm of your speech, none of that is copyrightable. Copyright is necessary, but it is not sufficient for voice cloning protection, which is why we need tool number 2. Tool number 2 is the right of publicity. This is the legal right to control the commercial use of your name, image, and likeness, and in many states, your voice. Even when copyright cannot reach an AI-generated voice clone, right of publicity sometimes can, because the harm is the unauthorized commercial use of your identity, not the copying of a specific recording. There is no federal right of publicity in the United States. None. It's entirely state law, which means your protection depends almost completely on where you live. Tool number 3 is federal legislation specifically designed for the AI era. The Take It Down Act passed federally in 2025. It criminalizes the distribution of non-consensual intimate AI deepfakes and requires platforms to remove that content within 48 hours of notification. But the Take It Down Act is narrow by design. It does not cover commercial voice cloning. It does not cover fake AI endorsements. And it does not cover an AI version of you releasing a song without your permission. That is where the No Fakes Act comes in. It would create a uniform national standard governing when and how a person's voice or visual likeness can be replicated using artificial intelligence. But pending legislation is not law, and until it is, there is no federal floor of voice protection from AI. Tool number 4 is the one being tested in real time right now: federal soundmark trademarks for the human voice. Soundmarks are not new. They have existed in trademark law for decades. Think of the NBC chimes. What is new is using sound marks to protect a specific human's voice, and that started with Matthew McConaughey. In December 2023, McConaughey's company filed a series of trademark applications. They include a sound mark on the audio of him saying, "All right, all right, all right." Then, in April 2026, Taylor Swift's management company, TAS Rights Management, filed 3 trademark applications: 2 sound marks, the audio of her saying, "Hey, it's Taylor," along with album promotional language, and "Hey, it's Taylor," with similar promotional content. None of these voice trademarks have been tested in court yet. The USPTO granted McConaughey's. That means that the trademarks do exist. It doesn't mean a court will enforce it against an AI deepfake. And legal experts are openly skeptical, not because the strategy is bad in theory, but because of the specifics. If trademarks on voices become enforceable, the line between legitimate creative expression and infringement can get very murky very quickly. Now, let's tie this all together, because this is what most coverage of this topic misses entirely. These 4 tools are not alternatives. They are layers. The legal teams protecting high-value voices are not picking one. They are using all 4 together because each one fills a gap that the other leaves behind. Copyright protects the recordings. Right of publicity protects the identity at the state level. The Take It Down Act provides one specific federal hook for one specific kind of harm, but it is precedent for protection against AI fakes. And sound mark trademarks, if they hold up, provide a different federal hook for a different kind of harm. For artists, this stacking matters because no single tool covers your situation completely. Your recordings are copyright. Your performance identity is right of publicity. Your distinctive voice, if it qualifies, could be a sound mark. Each one operates on a different legal theory and gives you a different kind of leverage and protection. For athletes, this connects directly to NIL. Your name, image, and likeness are commercially protectable under your state's right of publicity. But your voice and your signature gestures, those are exactly what these new trademark filings are testing. McConaughey filed for motion marks of his gestures specifically. If that holds up in court, athletes with distinctive on-camera signatures could potentially follow the same model with success. For content creators, this is the area to watch because if voice trademarks become enforceable against AI deepfakes, that has implications for everything from impression-based content to cover songs to parody. The legal status of doing an impression on TikTok could meaningfully shift depending on how courts interpret these sound marks. The broader picture is this. The way we think about identity protection is changing. For decades, your identity was largely covered by a combination of rights of publicity and copyright. Now we're seeing identity broken into smaller, separately protectable pieces, potentially voice as one trademark, image as another, and gesture as a third. Whether courts allow that approach to succeed will reshape how every public-facing professional thinks about IP going forward. Here is what you now know that most people watching the news headlines don't. You know that copyright protects recordings, not voices. You know that right of publicity is your strongest existing identity protection, but only at the state level and only inconsistently. You know that the Take It Down Act addresses intimate deep fakes federally, but not commercial voice cloning. And you know that sound mark trademarks are the live experiment currently pending, untested in court, but representing the most significant attempt as of yet to give individuals federal level protection over their own voices. That is the legal landscape. That is what is actually protecting you, what is failing to protect you, and what is being tested right now to close that gap. If this was useful, share it with an artist, a creator, and an athlete in your life who are building careers in a world with AI. And subscribe, because as these cases develop, I am actively tracking what happens and what that means. I'm Stevie. This is Girl Code of Law. I'll see you next time.